gentlemen. I welcome members to the 27th meeting in 2012 of the Subordinate Legislation Committee, and as usual ask members to switch off any mobile phones. Agenda item 1 is instruments subject to affirmative procedure. No points have been raised by our legal advisors on the Pollution Prevention and Control Scotland Regulations 2012 draft, nor on the Judicial Pensions and Retirement Act 1993 Scottish Land Court Order 2013 draft. Is the committee content with these instruments, please? Regarding the Pollution Prevention and Control Scotland Regulations 2012, does the committee welcome the Scottish Government's withdrawal of the draft regulations as initially laid and their replacement with a revised version which clarifies the penalty attaching to a criminal offence provision in the instrument?
Yes.
I do. Thank you. Agenda item 2 is instruments subject to negative procedure. The Council Tax Reduction Scotland Regulations 2012 SSI 2012-303 brief which members have received recommends the regulations raise a devolution issue. The question is whether these regulations relate to matters which are reserved within section F1 of Part 2 of Schedule 5 to the Scotland Act 1998, or whether they are considered to have the purpose of determining liability for council tax other than for social security purposes. Regulations have as their objective the establishment of a scheme which replicates existing entitlements to council tax benefit support for persons who have not reached the qualifying age for state pension credit, and for persons who have reached that age and receive income support or income-based job seekers allowance for the financial year commencing 1st of April 2013 and subsequent years. I just wonder whether members have any comments to make on what's being suggested.
Convener, if I may address whether what is proposed is a benefit or not under Section F1 of the Scotland Act in Schedule 5. I think it's been suggested that it might be considered that what's proposed is a benefit, but I think on looking at the detail of the legislation, where in the Section F1 talks about benefits being a reserved matter, but in the interpretation it then goes on to describe benefits includes pensions, allowances, grants, loans and any other form of financial assistance, and then goes on to describe some of financial assistance, and the one in question here is in relation to housing costs or liabilities for local taxes. If we were to consider that this proposal for reduction in local taxes were to be deemed a benefit, the very real difficulty is that that immediately catches other reductions already in force, which are that, for example, a reduction in council tax for a single person dwelling in a house, and indeed reductions for second homes. So I think it's clear from looking at those that they are not caught by financial assistance and are not deemed to be that. So why is what's now proposed different from what's gone before? What's gone before, operated by the UK, is caught by this because it can directly lead to money being put in people's hands if the benefit that is wished to be given to people is greater than the council tax they may pay. That does not apply in this case, so there are no circumstances under the legislation before us where there is money directly paid to any council taxpayer. It is merely another form, in addition to the ones we already have, of reducing the liability for local taxes, and therefore does not pass the test of any other form of financial assistance. So I think in considering the advice that we've had from our legal advisors, and I think it's entirely proper that they invite us to discuss the matter, that we should conclude that this is not any other form of financial assistance, and therefore we should not, as suggested by our advisors, refer this to the lead committee. And my primary reason for doing that is because it creates potential threats to two other important forms of reduction of liability to local taxes, and I think would cause potential for serious difficulties. Now, of course, given that this is part of the official report of the committee, it is perfectly open to others to to consider the matter further if they wish. But I do not believe that as a committee we should refer it to the lead committee.
Thank you very much. John?
I take a different view from Mr Stevenson. Regrettably, this is not about whether or not it's a good idea or a bad idea or a good thing or a bad thing or about reductions or not, but it's about the process and whether or not the process is the right one that has been followed. Now, the government take a different view apparently from those who advise us. I'm of the view that we should support our advisors in this regard, simply because we're here to hold government to account, and if there is further explanation required by government of the point that Mr Stevenson is seeking to make on their behalf, then that of course is a matter for them, but I nonetheless think we should take the advice offered to us.
Convener, if I may, just for clarity, I do not speak on behalf of the government. I speak as a member of this committee. Just to be absolutely clear about that. And I think there is an important point of principle here that, you know, it's absolutely proper and right that we have this put in front of us to discuss. But if our role is always to accept and pass forward the recommendations from our legal advisors, I think that much diminishes the role of this committee in engaging in a wide range of important issues. I'll be supporting, incidentally, other recommendations in relation to this order that our legal advisors make. So I'm not seeking to remove everything that's said. Convener.
I'm delighted to hear that you will be. However, while you're not of the government, you are of the party of government, and nonetheless this is about the point of principle about holding the government and indeed the party of government to account, and that's one of the things that this committee exists for.
Thank
you, Chair.
I agree with Mr Stevenson. I think his comments are very reasonable, and I think it's appropriate that we indicate in those ways. I mean, what we're suggesting is something for the betterment of what's already down here. That I think that's our role, and I'm quite happy for that to be passed on.
Thank you. Any other comments, John?
I would probably tend to agree with Mr Scott here with regards to the process, and I think Mr Stevenson does, put forward good points, but I think whenever there's an element of doubt probably being raised by our legal advisors, I think the least we should do is probably explore that and to get a definitive response back from the from the government in that respect. And I do very well understand that there is a very, very important process that we should go through. And I don't think it's always a case that we should agree with what our advisors are doing, but I think it's something as important as what we're probably discussing here. I think it's only right that we should go forward with the recommendation put forward by the clerks, your advisors.
Yeah, thank you. Can I just observe that I think we do have the government's response, and I would, we do have that. I would also make the point that a definitive response from the government is actually not possible, and I'm sure it's not what you meant. A definitive response comes from the courts, and clearly we don't wish to be anywhere near there. That's the whole purpose of Parliament, is to make sure we never go anywhere near the courts. I would suggest, or at least a parliamentary scrutiny. Do members have any other comments? Well, we do seem to have at least a disagreement. I must confess I'm personally inclined to side with Stuart, because I do think this is something we just need to accept as being the way forward. I think we have the government's view there, and we're not going to finish up in the courts. I guess, well, are we going to get unanimity on this? I don't think we are. Okay, well, in which case I guess we're going to finish up voting. I can't remember when we last voted on this committee, but does anybody have any other comments they want to make before we... I think the basic proposition is that we accept the government's view that this is intra vires. That's the basis on which it's brought forward, and therefore see no need to report it. The alternative is that we feel that there might be an issue and wish to report it as such. So, as I say, does anybody else have any other comments?
Well, John? That we're not prepared to take the view that it might be illegal, but I will certainly be voting as the recommendations of the paper suggest.
Okay, in which case I think if nobody else has any further comments, then I think the proposition is the positive proposition is that we accept the government's view, and therefore we see no need to report this on this ground.
Just
please.
for clarity, it is limited absolutely to the issue of a devolution issue. Other matters are not covered.
Other matters are not covered because they will come up later. Okay, well, on the basis that we see no need to report this as a devolution issue, can I have a show of hands, please? That's the proposition, is that we see no need to report it. Okay, thank you. I think that's 5. And those against? Thank you. Okay, so that proposition is passed 5-2. Okay, can we then move on to the other issues, because we do have to consider the other recommendations specifically relating to this, and there are several, I think. Firstly, in Schedule 7, paragraphs 1, 2, 2 and 4, consequential amendments are made to the Council Tax Administration and Enforcement Scotland Regulations 1992, the Council Tax Reductions for Disabilities Scotland Regulations 1992, and the Council Tax Reduction of Liability Scotland Regulations 1924, which add references to the Council Tax Reduction State Pension Credit Scotland Regulations 2012. Powers contained in Section 1132 of the Local Government Finance Act 1992 permit the Scottish Ministers to make consequential provision which they consider necessary or expedient, but only those which are consequential on making these regulations. This does not enable provisions in these regulations which are in fact consequential on the making of the Council Tax Reduction State Pension Credit Scotland Regulations 2012, which regulations were not made at the date of making these regulations. Does the committee therefore also agree to draw the regulations to the attention of the Parliament on reporting ground E, as there is doubt as to whether these provisions are intra vires?
Agreed.
There will be a test later. There appears to be defective drafting in paragraph 3J4 of Regulation 20. That head 4 requires a student to be one in respect of whom a grant for living or other costs has been made under Regulation 38 of the Education Student Support Regulations 2011, Regulation 25 of the Assembly Learning Grants and Loans Higher Education Wales No. 2 Regulations 2011, and Regulation 5 of the Education Student Support No. 2 Regulations Northern Ireland 2009, which is intended that these references to regulations should be alternatives. Does the committee therefore agree to draw the regulations to the attention of the Parliament on the reporting ground I, as the drafting is defective? Okay. We do, thank you. At the same time, does the committee welcome the Scottish Government has undertaken to correct this error by laying an amending instrument, and does the committee consider that this should be done as soon as possible?
Okay.
Yep. The meaning of academic year as defined in Regulation 2.1 could be clearer. Reference to according to whether the course in question begins in the winter, the spring, the summer or the autumn respectively could be made clearer by defining for the purposes of this provision what the commencement dates for each season are and whether these dates coincide with the dates which are specified when the academic year is held to commence. Does the committee therefore agree to draw the regulations to the attention of the Parliament on reporting ground H, as the meaning of academic year as defined in Regulation 2.1 could be clearer? Thank you. Finally, the regulations contain some minor drafting errors. Firstly, in the definition of additional statutory paternity pay in Regulation 2.1, the insertion of A after the reference to Section 171ZEA is an error. Secondly, the inclusion of Regulation 4.3 is a drafting error in respect that it was not intended to apply the extension of the definition of young person, which is made by that paragraph, in each case where the young person is mentioned in the regulations. Thirdly, in Regulation 41.4c, the reference to Regulation 17A7 of those regulations is an error. It's intended to refer to the Job Seekers Allowance Regulations, but the title of the regulations previously stated is the Employment Support Allowance Regulations in Regulation 39.4. Lastly, in Regulation 64.3, family is omitted from the phrase that applicant or a member of the applicants is liable. Does the committee agree to draw the regulations to the attention of the Parliament on the general reporting ground in relation to minor drafting errors?
Okay.
Thank you. Does the committee also welcome that the Scottish Government has undertaken to correct these errors by laying an amending instrument, and does the committee again consider that these should be done as soon as possible?
Okay.
Thank you. While the committee does not report on the matter, does it also welcome that the Scottish Government has undertaken to clarify in Regulation 48.4b the reference in Regulation 17A7 of those regulations by also amending this provision? The amendment will expressly refer to the Job Seekers Allowance regulations. Thank you. The Housing Scotland Act 2001, Assistance to Registered Social Landlords and Other Persons, Grants, Amendment, Revocation Regulations 2012, SSI 2012-306. There has been a failure to lay this instrument at least 28 days before it comes into force, as required by Section 28.2 of the Interpretation and Legislative Reform Scotland Act 2010. As the instrument was not laid at least 28 days before it comes into force, does the committee agree to draw the instrument to Parliament's attention under reporting ground J? Given that this instrument has been brought forward to allow the Scottish Government to address the serious concerns raised by this committee and the Infrastructure and Capital Investment Committee regarding the amendment regulations, does the committee find the explanation provided by the Scottish Government for this failure to be acceptable? Does the committee therefore welcome the prompt action taken by the Scottish Government to address the defects in the Housing Scotland Act 2001, Assistance to Registered Social Landlords and Other Persons, Grants Amendment Regulations 2012? Angela.
Why is it we are? Why is this here, and why are we going through the motion of actually declaring this? What's the benefit of that?
I think the benefit of what I've just said is actually to put on the record that we register that the government has responded to what we've said. I think it's probably giving credit where credit is due, on the grounds that we then find it easier to be more critical when they don't respond.
I'm just wondering whether, I mean, I see this quite often in papers, and I'm just wondering whether there's in fact a need to do that in that way. I mean, we can just simply note that they've amended the documentation rather than going through this motion of welcoming the Scottish. I mean, surely that's their job in the first instance, and they've corrected a mistake.
Yes,
I'm not. I don't understand why we're giving them a pat on the back for correcting a mistake. I just want you to think about this. That's all. I don't want you to respond to it.
Convener, if the member feels that a present and future form of response to the government under these circumstances is to note, I would not wish to divide the committee on the matter.
Indeed. I think the point is understood. No points have been raised by our legal advisers on the Criminal Legal Aid Scotland Fees Amendment Number 2 Regulations 2012 SSI 2012-305, nor on the Rural Development Contracts Rural Priorities Scotland Amendment Regulations 2012 SSI 2012-307, nor on the Diligence Against Earnings Variation Scotland Regulations 2012 SSI 2012-308. I do think, unless anybody else wishes to comment, I note from our advisors that the Rural Development Contracts Regulations is now in its 10th, is that a 10th amendment? Yes. And if our advisors are finding it difficult to work out what the 10th amendment actually means, I think probably we should be suggesting to the government that they might wish to consider some kind of consolidation of that. Yeah. Not so much because it's got to 10, but I think we're actually being advised that it may be giving problems even at that level. Is the committee otherwise content with these instruments, please? Content. Thank you. Agenda item 3, legislative consent memorandum on the Marine Navigation Number 2 Bill. Under this item, the committee is invited to consider the powers to make subordinate legislation conferred on the Scottish Ministers in the Maritime Navigation Number 2 Bill. A briefing paper has been provided that sets out the relevant aspects of the bill and comments to their effect. Clause 1 of the bill amends the Pilotage Act 1987 to give Scottish ministers the power to specify that a harbour authority is not a competent harbour authority for the purposes of the 1987 Act. The explanatory notes to the bill state as follows: many harbours require ships traversing their waters to use a maritime pilot with appropriate experience, generating additional costs for shipping companies. It would appear from this statement that the purpose of conferring this power on the Scottish ministers is to permit them to exempt particular harbour authorities from these requirements, which would otherwise be compulsory in terms of the 1987 Act. Does the committee agree to ask the Scottish Government weigh the power to remove Harbour Authority's pilotage functions are considered necessary, how it intends to exercise these powers, and why it considers that the requirements of Section 30 of the Interpretation and Legislative Reform Scotland Act 2010 offer an appropriate level of parliamentary scrutiny.
Agree.
Clause 5 of the Bill inserts Section 40A to 40D into the Harbours Act 1964. Section 40A confers a power on the Scottish ministers to designate harbour authorities which may give general harbour directions to ships within, entering or leaving the harbour. Section 40B sets out how harbour directions are then made by harbour authorities designated under Section 40A. Section 40C makes it an offence for a master of a ship to fail to comply with a harbour direction without reasonable excuse. The power to designate harbour authorities for this purpose includes the power to amend or repeal any statutory provision of local application which the Scottish ministers think is inconsistent with the power to give harbour directions or unnecessary as a result of the power. In England and Wales, the exercise of this power is subject to the negative procedure. In Scotland, no procedure is specified. The Harbours Act 1964 is specified in Section 34 of the Interpretation and Legislative Reform Scotland Act 2010 as an enactment to which the requirements of Section 31 and 2 are disapplied. The effect of this is that, since no procedure is specified as applying to the exercise of this power, the order is not required to be laid before the Parliament. There is also a technical query on the use of the word enactment as the expression of local application in identifying the class of enactments which can be modified or repealed. The Interpretation Act 1978 will apply to provisions inserted into the 1964 Act, and in this context, enactment does not appear to include any enactment comprised or made under an Act of the Scottish Parliament. Does the committee agree to ask the Scottish Government to provide an explanation of A, the choice of procedure applicable to the exercise of the power, particularly as this differs substantially from that applied in England and Wales, B, whether the restricted definition of enactment found in the 1978 Act is appropriate post-devolution, and C, how the expression of local application is intended to operate in Scotland, given that subordinate legislation is no longer classified by reference to this definition.
Agree.
Okay. Clause 6 of the Bill inserts sections 17A to 17F into the Harbours Act 1964. The objective of these provisions is to introduce a process for the closure of harbours by ministerial order. Such orders are not subject to parliamentary procedure and are not required to be laid before the Parliament. It's also worth noting that the same aforementioned queries concerning the definition of enactment and of local application arise in relation to these powers. Section 54A of the 1964 Act applies the affirmative procedure to harbour revision orders or harbour empowerment orders which relate to a national development under the National Planning Framework or for harbours specified by ministers. As the Parliament has specifically chosen to apply the affirmative procedure in relation to the creation of such a harbour, there is a query whether the closure of such a harbour should not be subject to any parliamentary procedure, or that such an order is not required to be laid by virtue of Section 34 of the Interpretation and Legislative Reform Scotland Act 2010. Does the committee therefore agree to ask the Scottish Government to provide an explanation of A, the choice of procedure applicable to the exercise of the power, particularly as this differs substantially from that in the creation of, that applied to the creation of harbours of national importance. B, whether the restricted definition of enactment found in the 1978 Act is appropriate post-devolution. And C, how the expression of local application is intended to operate in Scotland, given the subordinate legislation is no longer classified by reference to this definition.
Agree.
In that, in terms of a closure, would that be considered as temporary before it goes to any parliament, or is that time restricted? Is there a time bar on that at all?
No,
there isn't.
The effect of the order would be to close the harbour.
And that will be, and it won't go anywhere else other than the ministerial decision.
This is the question that we're exploring.
Ah, right. Okay. Thank you. Thank you for that.
Just for clarity, and I may be misreading it, it does suggest that, first of all, the Harbour Authority has to apply for or consent to the order. Yeah. Now, whether that's an adequate and sufficient check is another matter, but it isn't solely ministers. Oh, I think we should.
Okay, thank you. Finally, Clause 13 of the Bill gives Scottish ministers the power to commence sections 1 to 4 in relation to Scotland. In doing so, they may make provision generally, or for specified purposes, which may include incidental or transitional provisions, including savings. It's normal for commencement orders to be subject only to the requirement in Section 30 of the Interpretation and Legislative Reform Scotland Act 2010 that they're laid before Parliament. It's also common for ministers to seek to be able to exercise ancillary powers in connection with the commencement of provisions. However, it is not normal for these ancillary powers to contain the power to make incidental provision. In the absence of any information generally about the intention behind the creation of the powers in the Act, the committee may wish to explore this further with the Scottish Government before reaching a view. Does the committee therefore agree to ask the Scottish Government why it considers a power to make incidental provision in connection with the commencement is required, the circumstances in which such a power may be exercised, and why no parliamentary control is considered appropriate for such provision?
Agree.
Does the committee agree to raise all these questions in oral evidence next week?
Agree.
Thank you. Agenda item 4, High Hedges Scotland Bill. Purpose of this item is for the committee to consider the delegated powers in the High Hedges Scotland Bill. In considering the bill, the committee is invited to agree the questions it wishes to raise with Mark MacDonald MSP, the member who introduced the bill on the 2nd of October 2012. It's suggested that these questions are raised in written correspondence. On the basis of the responses received, the committee would expect to consider a draft report at its meeting on the 11th of December. Section 34(1) enables the Scottish ministers to make regulations which modify the meaning of high hedge as set out in Section 1 of the bill. As the bill will only apply to hedges which are high hedges within the meaning of Section 1, this power enables the Scottish ministers to vary the applicability of the bill by making subordinate legislation. Does the committee agree to ask the member to explain why it is considered necessary to take a power to modify Section 1 as a whole? This appears to include the possibility of removing entirely the conditions in paragraph A to C of subsection 1, when a power simply to modify these conditions would appear to be sufficient to achieve the changes envisaged in the Delegated Powers Memorandum, and whether the power could be used to modify the definition of high hedge in such a way that it extends to include individual trees or shrubs, and if so, why it is considered to be appropriate in a bill relating to hedges.
Agree.
Section 37(2) allows the Scottish ministers to appoint a day for coming into force of certain provisions of the Act. By virtue of Section 37(3), such an order may contain transitional, transitory or savings provisions. In relation to the power in Section 37(3) to make transitional, transitory or saving provision in consequence of that commencement, does the committee agree to ask the member to explain whether, standing the example in paragraph 25 of the Delegated Powers Memorandum, it is considered that the power in Section 37(3) permits the modification of primary legislation? If so, the basis of that view, and if not, how it is proposed to deliver the amendment to the Land Registration Scotland Act 1979 referred to in that paragraph of the Delegated Powers Memorandum. And does the committee agree to raise all these questions in writing?
Agree.
At least in the first instance. We do. Thank you. I think that brings us to the end of the meeting. Our next meeting will be next Tuesday, the 4th of December. Thank you very much.